Okay, now we can officially start. Thanks again for your patience and for your commitment, and I hope and I am sure that you won't regret being here in this panel that is going to be fascinating. We are combining here theory and practice, rules and implementation with an excellent panel of speakers who are going to drive us from the process of the legislator's intentions at the moment of drafting rules to the last chain of rule interpretation. Certainly, demonstrating compliance with the GDPR is not an easy task, and a solution that has been popular recently is the use of certain legal technologies which claim to provide, to a certain extent, GDPR automation. But obviously, this comes with certain risks, and this is what we are going to talk about today in this panel. I'm going to present our excellent speakers one by one. We have Thomas Zerdick with us, who is head of the Unit of Supervision and Enforcement in the Office of the European Data Protection Supervisor. Previously, he led the EDPS Unit Technology and Privacy, as well as a member of the Cabinet for the EU Commission's first Vice President with responsibilities on rule of law and fundamental rights, including personal data protection. At the European Commission's Directorate General for Justice and Consumers, Thomas was a key member of the team that prepared and negotiated the European Commission's data protection reform proposals between 2009 and 2016. Then we have Asha Biega, who is a faculty member at the Max Planck Institute for Security and Privacy, where she leads the Responsible Computing Group. The goal of her research is to develop and computationally operationalize principles of responsible computing, data protection and governance, and digital well-being. Previously, she worked at Microsoft Research Montreal in the Fairness, Accountability, Transparency and Ethics in AI group. She completed her PhD in computer science at the Max Planck Institute for Informatics. And we have Aurelia Tamò-Larrieux, who is an assistant professor for privacy, security and computational law and a member of the Law and Tech Lab at Maastricht University. She has a background in law and economics and is specialized in research at the intersection of law and digital technologies, with a particular focus on privacy, data protection, design approaches for privacy-friendly technologies, transparency of automated decision-making, automatically processable regulation, and trust in automation. We have at the very end my colleague Gianmarco Gori, who is a postdoctoral researcher at the Law, Science, Technology and Society Research Group at VUB. He is currently doing research in the projects Counting as Human Being in the Era of Computational Law, or COBICOL as we call it, and Human AI Net. Gianmarco has previously done research and strategic litigation in the field of labor exploitation, human trafficking, illegal discrimination, immigrants and prisoners' rights. And he is a member of the Bar Association of Florence, where he has been in practice in the field of criminal immigration and data protection law. And last but not least, we have with us Mikołaj Otmianowski, who is an attorney at law and data protection officer based in Poland. He spent most of his professional path working in various law firms, as well as several legal tech startup projects. These include also Red into Green application for the GDPR and cybersecurity risk assessment, which he's going to present to us today. And he is also a member of the Legal Tech Committee at Regional Bar in Warsaw. Thank you to all of you for being here today. And without further ado, I will leave the floor to Thomas.
Thanks, Desara. Nice to see so many of you, familiar faces included. Hello, Achim. First of all, indeed, the GDPR was not written with automation in mind. The main concern was essentially how to set up principles, responsibilities, rights and obligations, the rules of the road for our digital societies to protect the fundamental right of personal data in a way that it is technologically neutral. So I'm approaching the topic today of automation from the point of view of a lawyer, reading, interpreting, and applying the legal texts we have, as well as from the point of view of a supervisory authority. And in that context, it's important, I think, to understand when you do read the texts, which by now, of course, you all know by heart, because it's already 5 years that you know them by heart. The GDPR in particular puts an emphasis on two important principles. The first is accountability by the controller. What does that mean? The controller needs to be responsible for compliance. But even more importantly, certainly from a data protection supervisory's point of view, the controller needs to be able to demonstrate accountability and compliance. I would add every second where a controller breathes and processes personal data. We all know, you all know, since 5 years, this is not just a box-ticking exercise. This is a obligation which applies to all processing operations and for the entire life cycle. And it is for the controller to carry the burden of proof of compliance and to demonstrate this, as thankfully the European Court of Justice has already stated in several cases. Second important principle in this context for me is, of course, the risk-based approach. The GDPR emphasizes the more risk for data subjects, the higher the risk for data subjects, the more efforts are required to mitigate those risks. And obviously, as you can imagine, what can a controller do? The controller needs to have appropriate technical and organizational measures in place. This is a requirement. You need to have those in place, and that's something where supervisory authorities will come and check. So starting from that level of understanding, maybe limited, maybe not, we will discuss later, I see certainly avenues, paths, points to consider how you can go about automation and GDPR compliance. Obviously, there are potentials for handling GDPR compliance tasks more efficiently. We all value human beings, but of course there are some areas where technology can greatly help us. You can, for example, manage user consent, you can handle data access requests, you can monitor possible data breaches. This is some of the areas where I would believe organizations would be motivated to introduce automation. Second point would be reducing human error. GDPR compliance means taking care of data, means taking care in many cases of very sensitive personal data. Automation can reduce a risk of human error because human error still is a very large part of and cause of data breaches. If you look at the statistics, we in the European Data Protection Supervisory Authority alone in 2022, over 50% of notified data breaches were resulting from human error. So there is a great opportunity there to consider automation. Coming to the data protection principles, data minimization is a core foundational principle in the GDPR, and programming your systems to collect and store only necessary data is something which automated systems can help in complying with that principle, for example. Record keeping would be another area where I see simply from the text of the GDPR how technology and automation can help. Controllers need to have detailed records to understand what's going on. Common sense approach. If you don't know which personal data you're processing, you won't be able to achieve compliance, because then you'll never know what you need to comply with. So automation can help here with precise, consistent, and readily accessible information. Two more points which are not directly data protection, but they're very important. Obviously, cost effectiveness and scalability. The more personal data you handle, the more interesting it might be to come with tools which help you manage those data. And last but not least, from a data protection supervisory authority, automation can be a tool for enforcement. We in our office, we use automation to ensure compliance by controllers. We have what we call the Web Evidence Collector. It's an open source software which a colleague of mine has developed and written. That is a tool which we use in our supervisory efforts to collect evidence from websites, for example, to check automatically which cookies are being set, which third-party requests are being done. The software automatically goes about, collects screenshots, puts all of this in reports, and we use it then as a foundation for our supervisory enforcement work. We have received an award for innovation for the software from the Global Privacy Assembly. We're very proud of that. And you can download it for free on our website. It's called the Web Evidence Collector. So I come to my short conclusion already. I see a potential for automation to assist with the GDPR compliance. There certainly is a great potential for supervisory authorities to use automation to enable compliance and supervision and enforcement work. But it must be understood, obviously, that this can only assist. Controllers are still obviously under the final obligation to understand what they're doing, what are your obligations under GDPR, and then you need to use and correctly configure any automation or any system you're using to try to achieve that compliance. And I'll close with that and happy to discuss more with you all later.
Thank you, Thomas. You mentioned that you were part of the drafting of the GDPR, and at that time there was no discussion about automation in this regard. So my question would be, do you think that certain provisions of the GDPR, even though unintended by the legislators at that time, sort of push towards automation as the only way to be, for the controllers to be compliant? And if yes, and what normative implications would arise, if there are any normative implications?
Thanks. Well, like I mentioned, Desara, I think data minimization is for me a principle where you definitely would benefit greatly from if it's done automatically. The same way as you comply with storage limitation, data retention periods. The best personal data is the one which you delete, because then if you don't have personal data to take care of, then you don't have to look at all of this. So if you have systems which automatically delete unnecessary personal data, fantastic, no problem. Second area I would argue is the GDPR is very much putting an emphasis on data subjects' rights. Right to access, right to rectification, right to erase personal data. And again, given the vast quantities of personal data which are flying around there, doing all of this manually can be done, needs to be done, but if there is an automated solution to handle this correctly, that could be useful, given that we all live in a world of technology. But let me conclude on this. All of this may lead to the use of automation, but of course there are still then other open questions which result from that, like a controller which uses automation needs to understand what it does. You need to know what the system does, because as a supervisory authority, when I will come and do an audit, I will want to know, why are you using this tool and what does it do? And are you actually effectively doing what you promised to do? There are, for example, systems in this world when a data subject has an access request to his or her personal data, then as a controller you must guarantee that your automated tool searches actually all your databases to find out which personal data are being processed. And believe me, there are still systems in the world where a search is not possible, or there are separated and segregated systems where then an access request will always be incomplete because they're not being searched. And that is a clear violation of the GDPR requirements. So there is always a caveat to do: accountability, accountability, accountability.
Thank you, Thomas. Personally, I think that sometimes having the databases spread all around and not everything in one place, it's actually a good thing, as it provides better security. But you, in your talk, you also mentioned human error, and I'd like to move to Asha by maybe you can also tackle a bit in comparison with human error. What about the technical error?
Yes, I'm representing a computer science perspective on this panel. In some of our research, we do try to probe the limits or try to understand the limits of automation when it comes to different data protection principles. But before I started in academia, I worked as a software developer or software engineer for some tech companies. And I remember in my privacy trainings, I would see terms like data minimization, for example. But then I didn't really know what that meant in practice in terms of the code that I have to write or in terms of the data processing pipelines that I have to build. And this sort of observation that I had back then motivates a lot of our work these days, where we basically try to explore what these principles might mean in practice, because we as computer scientists, we have to operate at a slightly different level, right? So when you say that I have to minimize data or the data has to be limited, adequate, and relevant, it's still too high level for me to know how to translate that into an algorithm or into code. And so in our work, what we try to do is to come up with some more concrete interpretations and mathematical definitions and algorithms, and then try to see if we interpret those principles in this way or that way, what the consequences would be. So we run some simulation studies and we run some user studies to understand whether those are feasible. And so in my perspective here, my perspective here is sort of based on the takeaways from this research. In most of our projects, we quickly realized that full automation is unlikely to happen. It's really hard to do. And there are many reasons for this. Here I want to mention just two. One is that when we try to interpret things in mathematical or algorithmic ways, we quickly realize that there are many possible interpretations. And for me, as a computer scientist without a legal background, none of them seem better than others. They just seem like different options. And so how do we know which of these interpretations we should follow? These systems, so when we try to implement different interpretations of those principles in concrete systems, the takeaways are going to be different depending on what the system is and what the system does. So we would implement them differently in a search engine and differently in a recommender system and differently in a classification system. So that already complicates the picture. But then in some of our projects, we realized that even if you work within a certain kind of system, for example, a recommender system, the concrete algorithm that you use is also going to impact, for example, the extent to which you can minimize data according to different interpretations. And so we need some guidance on how to proceed, even if we know that there are different options. And so that brings me to my second point, is that in our work, what we try to do is to dive deep into those principles and try to understand what they might mean in practice. But when we emerge with all those takeaways, we need to understand what is the intention behind the law, so that we know which of these takeaways we can discard, which are just not important, and how to compare, how to proceed. We also learned in some of our projects that the extent to which we can automate is going to depend on a specific provision. That's the next reason why reasoning about automation is quite complicated here. So my takeaway for now, or at least my stance on this, is that we're going to need some human-in-the-loop approaches to automation, but the extent to which a human has to be involved is going to depend on a specific provision in which we're thinking. So in some cases, it might be that we just developed a toolkit of different options, and the person who is the decision maker has to select the right computational approach. In some cases, computer science can offer computational evidence through experiments or through user studies that then can be used by the decision makers. And with this, I'd like to
thank you.
end my opening statement.
Thank you, Asha. I like that you mentioned that full automation is unlikely to happen. But then I also heard math definition, and it already turned the red light to my head. And that's why my question is related to that. So what sort of provisions of the GDPR do you think can be reduced to code, and how reliable would that code be?
In my experience, some of the provisions are more amenable to automation than others. Principles like data minimization, when I hear the way they're defined in the law, it just rings a bell in terms of some of the approaches that we implement in computing, so it's some algorithmic approaches. So then by analogy, I can offer some concrete steps forward in terms of how this principle could be implemented. So that was the case for the principle of data minimization. We have seen this also in the right to erasure. We know this leads to some interesting technical problems like how to delete user data. So those two are the two principles where I think computing can offer lots of insights in terms of the algorithms. We have an ongoing project that looks into purpose compatibility assessments, and this is one example where I think automation is really hard, and where we think we can offer some computational advice, some computational evidence, as I mentioned before, but in the end the decision will have to be made by people.
Thank you.
So, and just as a final thought here, at this point, I don't really know what are the characteristics of these principles that make them more or less amenable to automation. For now, I think we just have to try and see what the limits are for each provision.
Thank you very much. We'll now move back to the legal perspective. Aurelia, please.
Yes, thank you very much. And I actually want to pick up on something that Thomas said, or even started with, saying that the GDPR was not written with automation in mind. And I think it's interesting because it also kind of, if we look a bit back also a bit at the history and the kind of legislative developments in that area, you kind of really see how still there is this link between the law and automation, and the need to also automate then certain processes. And law and automation is really not something new, right? Like especially like when you think of intellectual property rights and copyrights, there was always like strong incentives to automate certain legal provisions. Of course, there you had very different incentives, or you have still very different incentives from the market players with respect to this automation. And then, but with respect to privacy, for a very long time, we have and still have and are developing like these privacy-enhancing technologies, or these PETs, and this is also not something new, right? Like something that we know from the 70s and 80s and onwards. And as Lee Bygrave once said, like the problem with these pets is just that they are not like household pets. They are just like not friendly, not usable. No one really likes them. And this is really what kind of then changed the mindset and led then also to privacy by design. When you think of the very early stages with Anke Wukian promoting her new approach and this much more holistic approach to privacy, and looking not only at the software and hardware, but also at the business practices and the whole kind of organizational structures and how to promote this privacy. And we see this also reflected in the legislative history or kind of communications. So we see kind of this more early kind of approaches towards privacy enhancing technologies, which had maybe more narrow focuses and were kind of, you know, at times just confusing privacy for confidentiality and focusing only on security, or just focus on another aspect, such as, you know, transparency or anonymity, but had a much more narrow focus. And also in the legislation or like policymakers kind of reflected that in their reports, right? Like, well, in maybe more like 2007, you see more like reports promoting pets and the development of very specific, you know, security mechanisms. There is like kind of a change in perspective and approach toward like automation for privacy, and this idea of privacy by design. And actually also like in a paper of the the European Data Protection Supervisor in 2010, you see kind of in their report, which is called Promoting Trust in Information Society, kind of this push for design approaches and an idea towards, you know, automating privacy protection, so to speak. And also the case law reflects that in a certain way. When you look at even like the EU Court of Human Rights, but also like the ECJ with the Google Spain decision, also like asking for, you know, reconfiguring certain aspect in order to kind of automatically enable individuals to make use of their rights. And we see this reflected in the GDPR, right? Like also Thomas mentioned, as a key principle here, accountability, and also within the accountability principles of the GDPR, you also have this notion to be able to demonstrate the performance and the compliance with the regulation, and also here technical and organizational measures are mentioned. Of course, we have privacy by design, and today there was this great panel actually here, right, from FPF on how privacy by design has been becoming more and more enforced, and so we see there's also an uptick on that matter, and we see here like this notion that we need appropriate technical and organizational measures in order to comply with the whole regulation. So like in itself, then Article 25 doesn't have a body, but like really refers back to the whole regulation, which also pushes then to implement technical like automation in order to comply with these norms, and that's interesting. And then we have also like other norms. I think also yesterday there was a workshop actually by two people represented here, Soleil Huban and Max Schrems, also like on privacy signals. And we see also here, right, the right to object also says like, okay, you have a right to object, and this should also be able to be done through automated means, using technical specification, and this kind of really opens up this notion, okay, we can have like privacy signals, we can up on top of that, we can build then new tools in order to be able to kind of even enforce further individual rights. So this really opens up, in this sense, this automation really opens up like this all new era, not just to comply, but really just to be able, even enable users to make use of their rights. And I think these are very interesting prospects here. Yeah, the workshop yesterday was on the advanced data protection control, which is very different from the global protection, global privacy control that is pushed in California. But also here we kind of see kind of this push towards automation in order, to ensure that certain rights are complied with, even if the scopes here are not the same. And this kind of also links back to what Asha said, though, like, okay, like we see that there's this push for automation, but then the question becomes, well, okay, so how much is actually really possible? And maybe also like how much do we want? Like this is always also a question to ask, right? And in the paper we call it a bit like the luxury of law, and sometimes also the necessity of law to be vague and to be open and to be able to change. And this luxury of law, has then consequences, right? Like if you have semantic or syntactic ambiguity, of course, this has a lot of impact then on automation. And a case that has nothing to do with data protection law, but that really illustrates this point so clearly, was a case actually from the US, the Oakhurst case in Maine, where truck driver complained or wanted to be compensated for the overtime, and basically the problem in the law that led to unclarity was a missing Oxford comma, and that led to a court case, right? So like just a comma in the law would lead to another kind of potentially different ways in how you would implement this automatically. So kind of this also shows, right, like if we bring this now maybe back to the GDPR, very often the word appropriate or legitimate measures are used. So also here, right, like leaving a lot of room on how we want to interpret this and what, in which case, what can be useful. So this leads kind of then this question, right? Like, okay, so how far can this actually go, and how far do we want it also to go in certain instances?
Thank you, Aurelia. And you touched a bit upon my question, which would be that, of course, automation solves some problems while we still have some problems that need to be solved manually. But does automation create new problems while trying to solve the existing problems? And if yes, where does the balance weigh?
Yeah, thank you. Yes, I think so. But I think it really depends on you know, like what the reason, like the underlying reason of why there is a problem that is created. So, like in the paper, we present a bit a typology of different ways these automation can occur, and depending on kind of these, you know, maybe the aims or the degree of mediation by computer and how much is kind of done more kind of traditionally, manually, or, you know, like encoded more through imperative programming languages rather than more like data-driven, uncurated approaches, this really is going to change then the way also kind of what potential issues can arise, right? So we really have to look at these different aspects. And for instance, like if we just take the degree of mediation here by a computer, for instance, there can be different issues or problems that arise for again, different reasons, right? One can be these attributes of the law that I just mentioned, you know, because of ambiguities in the law, but also maybe because the law also, you know, should evolve. Like I think also here there's a good paper by Jennifer Kobe that talks about this reflexivity of law and how kind of the interpretation also evolves and interacts with us on a daily basis. So there are problems that arise just from these attributes of the law itself. Also, when you think of automation, especially kind of within the judiciary system, a concern that is then often raised is, oh, are we freezing the law? Are we just stopping at a specific status quo, right? And then you have other kind of issues or problems that arise depending or because of the attributes that are more relating to code, right? Transparency can be an issue depending on how things are automated. So it really depends there, on the specific implementations.
Thank you. Well, besides the fact that of the ambiguity of the law, I also think that law was actually meant to be interpreted by humans rather than by machines, and this makes it even more complicated for the automation process. Now we will move to a completely different part of the panel, where Mikołaj is going to present his tool, which deals with GDPR compliance automation.
Turn on. What should I do?
Yeah.
Yes. Brilliant. Hello there. Thomas wrote the GDPR, and I have to comply with this and apply with myself and with my clients. And now I will tell you, it will be a short story how we comply with GDPR and what is our idea. I am a lawyer, and one day I met a guy who was internet specialist, and we set up the company, and we figured out that we will advise as a consultant with GDPR. And to some point, we are doing this with using Excels and Word and emails, and we figure out that there is a moment that we need to change and automate this, because it's we cannot show and demonstrate accountability. We cannot demonstrate anything, and when we grow up and we had more clients, we couldn't serve them properly, in our opinion. So we figured out that we need to create a software which will help us with this. What do our software? Our software help the companies to to follow the rule of accountability. We have a register. In our software, we put a lot of registers, which are obliged by the law, but also the one which we think that our clients need in order to comply with GDPR. Not only a register, in our system we can put proof that you follow the law, and you can put some agreements, you can put some information from audits, and all of this information you can have in one place in order to demonstrate that you follow the GDPR. And what we are able to automate, I can, from the perspective of automatization, I can think that one part is the register, because this is the huge part of GDPR, and this register has to be updated all the time. There is a lot of information inside. So we figure out that this is one thing which we automate, and the other thing which we are working on is automatization with handling requests from natural persons, handling the incidents, and prepare the notification for DPA. At the same way, we are working on the to produce in automated way obligation information from our software. So it will be one button, and the obligation information will be prepared. But we are working on that. The main thing which we have in our application is because we want to follow the risk-based approach, and we are for 2 years. Half of my team become a R&D team, and they were thinking for 2 years how to follow this rules. And after these 2 years, we figured out a methodology. We had a great Excel file, and we turned this Excel file into a web application. And after we are thinking how to do this. And the final outcome from our research was that we have to combine supporting assets with threads and the processes, and everything inside is assessed in the proper way in order to comply with GDPR. And when we combine this supporting asset, processing activities, and threads, and this make a lot of instance of risk. It could make us a lot of instance of risk, so we need to automate this. And for this, in this example, I show you that there is only 30 processes, so it's not a huge company. It's 30 processes is average company. Only 30 threads and 30 supporting assets. Usually, companies has around hundreds of supporting assets to be assessed. And when we multiply this, we have 27,000 instances of risk. So we have to calculate everything. We have to have the whole to have a whole picture of the company. Then we have to assess this, and then we have to manage them. Without automatization, it's impossible. And thanks to our application, we know how to do this and how it works. Record of processing activities is second part which is automated in our software, because we linked all the information which are in record of processing activities. Our record of processing activities is much wider than the law says. We add some additional columns in order to use this data in other things, like in risk analysis, to prepare the register of category, to assess all stuff like that. And what is important, we linked a lot of information in register. For example, when you have supporting asset, is very often is linked with the processor. the information about processor is also linked with technical operational measures, and this and because we have this linking module, it's very easy to update and to change everything in our record of processing activity. Because, for example, you have Microsoft Office 365, and you just add this one asset, and the category and the processor show up. If there is a transfer to third country, it will also be the information will be in place. The information about technical measures that will be in place. So it's very easy to build the whole register and then work with this. And the third thing is register of category. When we have a processor and there is a lot of companies and our clients have, for example, they assign 20 agreements per day. And in order to have the register of category updated, they have to copy, usually they use Excel file. So they have to copy all the information again and again and again. And we figure out that this is, that we can create a category, and then we need only to add the new name and the contact details to the register. So in order to prepare the register, you can just add 20 new controllers names and the contact details, and then just press the button, and the new category will show up in the register. The information are taken from our register of activity. So this is how we automate, how we are thinking about automating with the registers, and it's very easy and it's very complex. And what we are working on the data subject access right and how to answer in the way which is automate. It was said that the system should be connected to to gather information from the whole company. It's quite complicated at this moment, but we are working. We have a project and we are thinking how to answer this question, because our clients has this request and we have to help them to answer them. At the same time, we have incident report. If it's working under Polish legal obligation, so it's not ready for outside Poland. But when you start filling in the form of incident, automatically inform that there is a standard form which we should file into the DPA is automatically filled in. So we are assessing the risk, and in the same time the form is going to be ready to fill in if we decide that the risk is high for the natural persons. So this is how it's work, and this is the kind of second part of this, which we can help with our software. I'm here because I was investigating Kohabikol, and they investigate my way how we produce our software. They investigate us as they ask us about our research and how we were thinking about it. So it was a quite really nice and difficult conversation. But we had a really nice outcome from this, and we learned that that our approach, which we follow for the whole time, that we will will automate as much as possible, but at the end we will give the power to the user. So we can automate everything, but then the user is able to change the places which are not assessed correctly, or there is something like that. So this is at the end user may manually manage everything. So this was very, very important. And we have a very extensive help module in our application. So in each place in our software, there is information why we decide to do something and what's happened if you push this button, what's happened next, and from which legal obligation this arises. So everything is written, and it's we translate this into English. So we know that it's 400 pages of instructions. So it's quite a huge book in our application. So this is how it's work. And last slide, I wanted to show you that because right now we combine GDPR risk analysis with cyber risk analysis. And without automatization, we would probably die, because if we multiply the same company, 27,000 of instances, and now we will assess at the same time cybersecurity, we will have over 50,000 instances of risk. And nobody can even write it down and then calculate and then assess them without software which helps you with this. So that's why I believe this automatization is very important, and this is possible to deal with this and to work with this. Okay, thank you.
Thank you, Mikołaj. Certainly a very interesting tool. I saw Thomas was taking notes, so most probably he will have some comments about that. But before I make you a question, I would like to just clarify something regarding the cubicle slide that you had, because the title is sort of misleading. So for the sake of clarifying the public, me as part of the cubicle team, we have developed a typology which my colleague Gianmarco is going to present now. The typology was not meant to select among the best legal technologies that exist out there in the world. So it's not really a ranking of the legal technologies, but it's only a group of legal technologies that we have picked out of many that we have pre-analyzed. We have picked those ones to focus on those ones so that we can include in the typology and present them as examples of how we analyze legal technologies in terms of both legal and technical implications. But that doesn't really mean that we believe those are the best ones or the worst ones. It's just a method that everyone can use to analyze also other legal technologies that exist that we didn't tackle. Sure.
Sorry about that. I'm too much marketing.
Yeah, typical of businesses. And talking about business, in your opinion, since you are a lawyer but also a business leading a business who offers, who provides GDPR compliance tools, what do you think should be the liability of this type of businesses? Where do they stand in the liability chain?
As a lawyer, I was thinking about the liability for a long time when we started this project, and I see this in probably in few places, the liability for the project, for the product. And first thing, at the beginning I was thinking not to process any personal data in my application in order to avoid GDPR issues. So this was my first feeling, and until we were working only with the risk analysis, I was almost done, because there was only metadata in my application, so there was no problem with GDPR. But when we add the module with incidents and with personal requests, of course, there is a lot of data, personal data in our application. So I had to follow the GDPR in these terms. So this was what I was looking to avoid. In terms of the responsibility for our methodology, in my terms and condition of the agreement, I put the whole liability on client, because the client is the controller, and he choose my methodology. I demonstrate how it's work, and he choose one, because there is a lot of methodology how to assess the risk on the market. So he picked mine on, because he believed that with his advisor this is the right one. and because of that, the client is responsible for what he assesses. And the very important thing with this assessment is also that the outcome from this assessment it's rely on the information which you put into this report and how you assess the risks, because you can do this very generally or you can do this very detailed, and depends on the data you put, the outcome will be, and you will assess the risk. So I put the risk on client on that. And probably there is a third one which I cannot put on client, and this is my risk. It's a risk of security of our software, and we try to be as secure as possible. We use the best technology in order, and we ask some specialists to do the pen test on our application. So every release we have a pen test going on. So we feel that we do our best, and we do in order to give a security to the client and to his data.
Thank you. Now I'll give the floor to my colleague, Gianmarco, who is going to present the typology which was developed by our team at Cubicle.
Let's see if automation works. Well, first of all, thank you everybody for being here until the last moment of the day. So yes, as Desara was saying, like I'm going to present the typology, which is a tool that we have developed in the project Cubicle with our team that is composed of both lawyers and computer scientists. Basically, we've done a research that has gone on for like more than a year. A research that has as its object legal technologies, more in general. And we have collected a lot of information about these technologies, and the typology basically is like the way in which we present this information. This information that we have collected, analyzed, and reproposed to you in this form. The typology is again a collection of information about 30, as also Sarah was saying, legal technologies. So 30, not 1,000, not 5. It doesn't mean to be. It's not meant to be a complete, exhaustive analysis of what's out there. We had to make choices. We did make them, and what we tried to do is like to offer to the users of our tool a spectrum of a representative application. So we've chosen both applications that are in use, but also applications from the past. We have like the famous like British National Act from 1986, for instance, and not only application, so things that work or have been working, but also like we have focused also on databases, which we think are very important from legal automation now, especially with machine learning, natural language processing, but also systems that are just really first stage of development, and so just in papers, for instance. It's also not also like a collection of information that is meant to be updated day by day. So it's basically a snapshot of what was there at the moment in which we did the research, and both the size of the sample and the fact that again it's a snapshot might be seen as a limitation of our work, and to some extent they are. But at the same time, our goal again was not that of being exhaustive, and not just that of like offering an analysis of legal tech, but that of offering a paradigm. So a paradigm in the sense of like a set of examples that people can look at, and a way to look at examples. So in this double form of like a set of information that we could provide, and also like a way of looking at information, of structuring information, of questioning the use of legal technologies. And the tool, as you see it now, is It's thanks to the work especially of 3 of our teams, Pauline McBride, Masha Medvedeva, and Lawrence Diver, which is in the audience today, and who's really like the man in the backhand of the system. And talking of backhand, that's really like it's quite the focus, quite the core of the typology. Because basically the typology revolves around this idea of like looking at the backhand of technologies, also in relation with what Thomas was saying before, like how do this technology works? So basically what we've done, the 3 main questions that animate the work of the typology is looking at these technologies, looking at what are the claims made by developers or provider of these technologies. What is the claim functionality of these tools? What is the technology aimed to do? Based on this, on the consideration and analysis of this, so which sometimes, as you can expect, it's like it's a PR discourse, especially when it comes from business, and it's interesting to see the difference between business, academics, government producing tools. But so starting from that, and so taking an approach that is quite in line with, if you want, with the AI Act. So intended use, what is the intended use? Then from that, we see how can this claim functionality be substantiated. And there is where it's interesting the interaction that we have had within the team between lawyers and computer scientists. So trying to cross-communicate amongst the different disciplines to try to look at how the technology works. So, and this is interesting because if you think like in terms of the intended purpose, which is to provide a service that has some legal relevance, of course, being legal technologies, and look at a machine and how a machine works, and how can a machine, how the working of a machine can actually substantiate a claim that eventually has something to do with a legal function, with the performance of a legal activity. And this will come back with a reference to compliance again. So a legal obligation and a machine which does something. How is that related? And finally, based on this, our question was like, how can, taking this claim functionality, the way in which the functionality is performed, achieved, what kind of impact can this have on the law, on the legal, which kind of legal effect, impact on the legal effect can it have? So when it comes to data subject rights, for instance, how claiming to do this and doing it, trying to do it in this way, eventually touch the substance of the rights. But same thing for controllers or processors. So if you think that you are doing this by this, how is this eventually going to touch your responsibility and your obligation? But let me show you a bit like the filtering interface that you can find in the home page of the typology. As you see here, you can find the 30 systems that you can filter by end user. We have selected courts, legislators, policymakers, software developers, natural person, and so on. We have divided them also like depending on the say the computational approach on which the system is based. So code and data driven. You can find more details on this distinction in the methodology. And eventually, and here we come finally to the compliance software, we have divided and collected and then divided the systems based on the functionality. And we have done this also for compliance support. And we have 5 systems in our topology, 4 of which are Gdpr compliance system. And there is, you can compare different legal tech using this icon. And this shows the basic, more objective features of the tool. And then clicking on them, you have the profile of the single system, in which you can find our answer to this set of 8 questions. Again, the claim, the substantiation, and further questions that concern the creator, the jurisdiction, because of course when it comes to legal technology, this matter, because a technology developed with having in mind a certain jurisdiction is not going to work probably in another jurisdiction, and so on and so forth. So and the analysis that we've done with respect to this for GDPR compliant support system is interesting because it shows that, well, first of all, that they're each try to automate a different part of the activity that are involved in compliance. So we have systems for consent management, we have system for generation, revision, update of privacy policies and cookie banners. We have then system that are used, that are intended to use to facilitate the exercise of data subjects' rights. But yeah, going back to what Thomas was saying, so the importance of, like, from the perspective of the controller or processor also, to some extent, who decide to use this technology. So the mindset of the typology, and again, in the sense, the paradigm, trying to show an example, basically, of how this question can be asked and which kind of information eventually you might find or not by trying to answer this question. And I think in the perspective of providers, and in the perspective of controllers, but also in the perspective of that subject, this kind of like this grid of questions are very important, because eventually, as Mikołaj also was saying, the obligation to comply, the duty to comply, eventually is and is going to stay on the controller, whatever the means, the technical measures that they adopt. So it's very important to have an understanding of how the technology works. So, thank you.
Thank you, Gianmarco. My biased comment is that this is great. But I'm not the right person to say that. I'll skip the question to Gianmarco because I want to see whether there are any questions from the audience, since we have only 10 minutes left. Yes, I see someone in the back.
Hello, thanks a lot for the very interesting panel. My name is Sören Human. I'm the director of the Sustainable Computing Lab at the Vienna University of Economics and Business. Together with Max, who is not here anymore, we have developed the Advanced Data Protection Control, the ADPC. Just to be very fast, we don't have that much time. I just read four sentences from our specification. It is the user's choice how to communicate the exercise of GDPR rights to a data controller. The user could send an email, letter, pigeon, as Max always says, or clicking a button or whatever. Article 21, paragraph 5 of GDPR express that the data subject may exercise his or her rights to object by automated means, using technical specifications. Recital 32 of the GDPR also makes clear that requesting and giving consent could take many forms, which could include ticking a box, as we do all of us today, or choosing technical settings for information society services. I'm reading the law like one by one. Also recited 66 of Directive of 2009, which updates the 2002 e-privacy directive, likewise states that, this is the quotation, the user's consent to processing may be expressed by using the appropriate settings of a browser or other application. Which means we do have the law that supports automation from the data subject's perspective. We have the ADPC, that is the technical implementation of this. And then the question is, what is missing? And from my perspective, what is missing is enforceability, or a real will that we really start to use this. My question specifically from Thomas is how can or will data protection authorities, European data protection authorities, support an initiative towards automation of users' rights, practicing of their rights, and how do you see it? Why this has not happened in the last 5 years? And if you want to work together, what are your suggestions, really practical suggestions, to make what we talked about it here to the next stage? Thanks a lot.
Thank you. Thomas, you want to take that?
Sure. Congratulations, you have identified and found the hidden gems in the legal texts, where there are indeed many hints at what could be. But as I said, these are the hidden gems, and they were not at the mindset of everybody who was doing this. So, but I fully endorse that. Why should technology only work one way? Of course, if automation, if tools can help us as users to have our rights enforced or made applicable in practice, absolutely, absolutely yes. But I think the hard work is in showing that it actually can work and showing that there are ways to do it, not just for controllers, but also the other way around. From a data protection supervisory authority perspective, we'd welcome this. Like I said, we are trying to make use of those tools ourselves. And if there are tools out there which help data subjects, I'm sure you will find an open door in our office for that.
Do we have any other questions? Yes, Lawrence?
Hello, thanks everyone for some really interesting presentations. I'm thinking from the perspective of SMEs. As Thomas said, and as we all know, the controller is ultimately the potentially liable party. But I'm thinking from an SME point of view, there's very much an incentive to make use of tools that help compliance and automate compliance because they don't have the resources to have in-house assessments and so on. So if that's true, if that's correct, and in essence for SMEs the incentive is to make use of automation, are we outsourcing the interpretation of the GDPR onto the creators of those automation systems? And if so, who is checking that those systems are kind of meta compliant? Is there sufficient consideration of that? And also, kind of, are we creating a sort of a time bomb? Because if enough SMEs start to invest in these systems, and it turns out not through anyone's malfeasance or intention, but perhaps a mistake or a change in the law which hasn't been reflected in the design of the automated systems, are we creating a time bomb whereby many SMEs might rely on a system which turns out to have been inaccurate? In that case, what would the situation be?
Excellent question. Lawrence, who do you want to answer the question?
I guess Tamò, because he's from the supervisor group. Actually, really everyone. Maybe Asia as well, from the perspective of how you actually build these things, and you were talking about the principles and embedding them. The principles might change when they're interpreted by the court. So,
okay. I'll ask you to be very quick because we only have 3 minutes.
Right. I'd say it's one of the biggest questions that we try to deal with in our research because, indeed, as you mentioned, when we propose a solution for automation, it sort of embeds certain behaviors and certain norms. And very often, especially when the solution is complex enough, it's hard to tell how the system exactly behaves. And so this is why I think it's very important to conduct those simulation studies as part of proposing the solution to really try to understand like what is the emergent behavior of that solution, or how does it behave under different conditions, and be that part of the solution as opposed to just providing an algorithm or a definition. So I agree that this is an issue.
I wouldn't be so pessimistic or risk aware, because obviously accountability simply means you're doing all you can and what you should do to show and demonstrate compliance. And I can tell you from a data protection supervisory point of view, of course it's much better if you come and show me, hey, I've thought really hard about this, I've been using this tool and it seems like it works how it does, rather than, for example, using software out there off the shelf, which is the complete opposite of data protection by design, for example. So it's part of the risk-based approach. You are processing personal data, you take a risk of non-compliance, and you need to then ask yourself, what can I do to counter and mitigate that risk? And if you choose a certain tool, great. maybe it'll help you, or maybe it won't, but the fact that you have already taken that decision certainly is speaking in your favor, I would argue. And life is full of change, so that wouldn't be a problem, I think.
Thank you. Since we have to close, I'll ask the other three panelists who didn't receive any questions to quickly say your key takeaways, but please be short, in 2 sentences.
Sure. Happy to quickly go first. Yeah, I think from all I hear and also like from what we see in research, I think there's like one key thing that we should all do, and it seems so easy, but it's really, really hard, is like we need much more interdisciplinary work, like show what you're building up in your lab, also what we're doing at the Law and Tech Lab in Maastricht, like really sitting together, like computer scientists, lawyers, social scientists, psychologists, everyone, and working on these tools. And I think it's not like, it's logical in my mind why like the best technologies, also when we think of the COVID tracking kind of technologies, they came out from academics and academic discussion, because these things cost a lot of money, because it's expensive and it's time consuming to actually sit together and develop these automated tools. So that would be my takeaway.
Thank you. Mikołaj?
From my perspective, it's this we need this automatization which we are working on, because otherwise it's impossible to follow all of this obligation from the Gdpr. And as Lauren says, this SME, this is complicated for them because they have no resources for that. So they need to have a system which do this for them actually. And as much as knowledge we will put into the software, then that will be much easier for them. So this is my conclusion.
Gianmarco?
Yeah, I would say that I'm still not sure I've understood what is automation of compliance. But I think it's interesting to think about it. But like, yeah, so just the very idea of putting together automation and compliance, it seems to me like a conceptual puzzle, of course. I can imagine like the automation of parts of the activity that are required to comply, but for me like it's a normative activity that can be performed only by the subject that the law indicates. I don't know, if I have an obligation to be here at a past 5 and I put an alarm to remind myself that I have to be here, is that automation of compliance to be here? Is that like, so because like, again, I feel like that automation involves like the use of a machine at some point, and but like machine, we don't have only computers and digital machine. We can imagine a machine also like very analogical way, and so I think it's very hard to really grasp and delineate what it is that we mean by automation. And I don't think that the problems that we think about when we think about automation comes from tools like Mikołaj's tools, which is like a structuring of information. We may be thinking about automated processing, automated decision-making, but the time has come and I stop here. Thank you.
Thank you, and I think that's homework for everyone. So you just gave us a homework of thinking what automation means for each of us. Thank you everyone for being here.